Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We'll
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please. Verbus Latina.
Literally not.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Getting back to...
Remember in the beginning when we started 110 years ago?
Yes, it seems that long ago. It's only day 4, though. It's only day 4. Getting back to the very beginning, where Kim R. was first in chat. Kim, congratulations. Everything IP related worldwide is your responsibility. We're punishing you with internet ownership for being prompt and punctual in chat. All right. Do we have Team Conrad here? Oh, let's go get Conrad. I see what you did there, Lisa. Awesome. Congratulations, Kim, on yet another win. We'll add this to your record. Alaska case is still happening. It's going on.
Work was going to go out.
We're going to be joining that one here in a little bit. We need to close. We have a poll? Apparently we have a poll. Let me see what it is. Happy National German Chocolate Cake Day. For all cake lovers, are you Team Center or Team Edge? All right, we'll end the poll. Let me just say that the correct answer was it doesn't matter as long as it's upside down in a bowl of milk. But that being said, I hate coconut. So we can't do German chocolate cake. Looks like Team Edge edged out a win in this one with 54% and Team Center 46%. I'm only Team Center if I go first, right? If I'm getting the first piece of cake, then I'm Team Center. No, I'm terrible that way. And you have to dish it up with your hands. Just dive right in and get it. Edge milk on the side. That's my favorite cake. I just can't do the coconut. It gets like stuck in my teeth. It sticks in me craw. That's what it does. All right. We'll be jumping up to Alaska here before you know it. We'll be catching up on that. Not the best audio, but we'll make it work. I take the whole cake. That takes the cake. All right, we're going to be jumping right now back to Wisconsin. Yes, Wisconsin. That's where we are. Yellow cake with chocolate frosting. Now you're speaking my language, Ronnie. Oh, my goodness. Ronnie Cambery, that is, yeah. Mm-hmm. I could do with that. If you can fix the Alaska audio, I am there. Caroline, here's the problem we have. I can't make it something it's not. I mean, which audio sounds better? You tell me. Is it this?
Miss Nadia. Okay.
Or this?
And then on August 7th, did anybody get a...
Yeah. We might have...
Was that unusual for her? Oh, for sure. And can you explain that a little more?
Well, she's always on her phone, and technically supposed to call out, not to text. So it was just weird.
And with your time working here,
yeah, we'll see what we can do. We'll get it working. I thought Ari could make something that's not. I'm magic. I'm magic. Sounds like I'm listening on the phone. Yeah, it's really compressed is the problem. It's thin sound. It's all scrunched together where it should be spread out and vibrant and yeah. Let's see. Well, all right, we're done with the poll. We're ready to go back to court. Mr.
State of Wisconsin versus Kevin Lychwick. Appearances are the same. Attorney Galloway is the standby counsel, is also in the courtroom.
We're going to
The court
closings.
made just a few minor changes to the final jury instructions. Those all had to do with spacing and pagination. So there were
used
no
the word
substantive
pagination.
changes. My plan is to provide
You're listening
12
to me.
copies of the jury instructions to the jury. I figure having all of them with their own copy on this case might be a good idea. And the verdict forms, Madam Clerk, did you submit the previous verdict forms to the parties? Okay. I do have four verdict forms here. They read verdict as to count 1, then there's the not guilty and guilty, and verdict as to count 2, not guilty and guilty. So if either party wants to see those verdicts, they are welcome to, but otherwise the language mirrors what's in the jury instructions.
Going pro se coconut
I
is
advised
amazing.
the parties, just before we called the case, that they are welcome to stand at council table. I offered a lapel mic to the state, which I believe they're going to utilize. Mr. Lychwick, you can decline the lapel mic if you want. I just want to make sure that my court reporter can hear you during your closing and make sure that the microphone picks you up. I really don't doubt that the microphone's going to continue to pick you up as long as the microphone's down on your table where it is right now and that you don't cover it with papers or anything like that. It should be fine.
Rebecca,
Anything
thank
else
you
we
very
need
much.
to take up before we bring the
OG.
jury in? Attorney Thompson?
No, thank you.
Mr. Lychwick?
There's purple.
No, Your Honor. Okay, let's bring the jury in.
Purple claiming that coconut's the way to go. Coconuts are fantastic. They have milk inside. Okay, what's not to love, right? Well, the coconut part, the meat of the coconut. Not a fan. Not a fan. Of course, stick me on a deserted island and I might change my mind, but pagination is the page numbers of documents. Oh, thank you, Northwest. You answered that before me. But I knew that before. I used the word earlier this morning, appropriately. I was impressed. All right, jury instructions and closing arguments. And then, of course, we need a poll. We need a poll about guilt and innocence because we're done with the evidence. I'll get that going right now while the judge welcomes the jury and gets things underway. Make sure you vote carefully. Give me a second to build it.
Thank you. You may be seated. Ladies and gentlemen of the jury, I'll note that you all have entered the courtroom without your note-taking materials because the evidence portion of the case is over. We're now at the instruction phase where I am going to instruct you on the principles of law to guide you in your deliberations. Unlike the opening instructions, these ones will be provided to you for reference for your deliberations. In fact, I'm going to print off 12 copies of these so that each of you will have your own copy of the jury instructions. Despite the fact that you're going to be receiving a copy of these, I do urge that you pay close attention to the instructions of the law that I give you now because they will help guide you as you listen to closing arguments as well. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts and the law. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of this information in this case charges that the above-named defendant, on or about April 14th, 2024, in the area of 1512 East North Street in the city of Waukesha County, Wisconsin, did cause the death of Carlos Maldonado with intent to kill that person, contrary to Wisconsin Statute 940.01 sub 1 sub A. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The second count of the information charges that the above-named defendant, between April 14th, 2024 and October 30th, 2024, in the area of 1512 East North Street in the city of Waukesha, Waukesha County, Wisconsin, did hide a corpse with the intent to conceal a crime, contrary to Wisconsin Statute Section 940.11 sub 2. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. Standby counsel has been appointed by the court to assist with the efficient operation of the trial. The defendant, though, is still representing himself. The defendant has appeared at times in court wearing orange clothing. You must not infer anything from this. This must not influence your verdict in any manner. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant caused the death of Carlos Maldonado. Cause means that the defendant's act was a substantial factor in producing the death. Element number two, the defendant acted with the intent to kill Carlos Maldonado. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Carlos Maldonado with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Hiding or burying a corpse. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant hid a corpse. Element number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with a purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something.
So
while motive
important.
may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not establish evidence of guilt by itself. You should give it the weight you believe it deserves under all of the circumstances. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant, only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial, and whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement deserves. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. The court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence. An exhibit becomes evidence only when it is received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of the parties, the court is not indicating any opinion about the evidence. You, the jurors, are the sole judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the court itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony and remarks to be stricken. Disregard all stricken testimony. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining what the credibility of each witness and the weight you give to the testimony of each witness, consider the following factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here.
Mending the poll now. Make
A
sure you
defendant
vote.
in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason for giving the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. Ordinarily, a witness may testify only about facts. However, in this case, witnesses were allowed to give opinions based on their experiences. In determining the weight you give to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you are not bound by the opinion of any witness. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. We will now hear the closing arguments of the parties. Because the state bears the burden of proof in this case, the state is allowed to go first and also make a rebuttal closing if they so choose.
We're 86%
Attorney
guilty.
Thompson, you may proceed.
8%, this is a travesty. Secret twin is the last.
Hey, good afternoon, everyone. Thank you so much for your patience over these last few days. There's been a lot presented to you, and you are here to perform your civic duty, and we very much appreciate it. We're here this week because of Carlos Maldonado, and we're here to find out and prove to you who killed him. And now, at the close of our case, the state has proven to you that Mr. Maldonado was killed by Mr. Lychwick, the defendant. As you heard from the court, the two elements of first-degree intentional homicide are that the defendant caused the death of Mr. Maldonado and he acted with intent to kill him. We also have an intent element in the second charge of hiding a corpse. So instead of repeating the evidence for both charges, my intent here with closings is to argue how all of these pieces fit together for both charges. First, when we consider intent, as the court said, you can't look into a person's mind, and that's fine. So what do we have here in front of us? Operation Slop Shop. We have dates on exhibit number 146, and it says targets identified. It goes back to November of 2023, and interestingly enough, when we look at those autofill sections on Mr. Lychwick's cell phone, that's when you start seeing Mr. Maldonado's name. And those autofills don't just happen. That is the user who has to manually input those names, and then the phone remembers it. Then we have him on exhibit 146 as the target of the first operation. And the numbering of all four of these operations is very important because when you look at exhibit 147, which is Operation Starling, it says at the bottom, the operation can commence since Operation Slop Shop is completed. Funds and reparations have been seized from Slop Shop, so for Starling, and all threats from the first operation have been neutralized. That first operation is Carlos. Now, how do we know that this note was written by Mr. Lychwick? When we look at all of the pieces surrounding this note, and even some of the context and additional items in there, we know that it belongs to Mr. Lychwick. So number one, it's found in his apartment. That's a really good place to start. He lives alone. He references his brother and his mother. He is next door neighbors with Mr. Maldonado. And think about all those German references. Absolutely fine to enjoy German history, to want to go visit it. That in and of itself is not criminal. But the whole point of playing those clips and showing you those conversations is to provide context and show that these notes belong to Mr. Lychwick and they were written by him. There's another name in Exhibit 146 that we have referenced several times of Raven. The sole reason that the state provided the information and the phone searches and the Google returns about Raven is to connect Mr. Lychwick again to these notes. That is the sole reason. When we look at intent to kill and intent to conceal a body, we're also looking at the medical evidence here. And we heard Dr. Scheel talk all about how they processed this scene, how they brought Mr. Maldonado back, and why they did those x-rays. And her words were very specific. When we have a concealed body, we need to be careful on how we process and examine. And when they do those first set of x-rays, that's when we see the 2 projectiles, which we'll talk about in a little bit. But Dr. Scheel determined that the cause and manner of death was homicidal violence by the 2 gunshot wounds, and his manner of death was homicide. We may not know how far away Mr. Lychwick was standing from Mr. Maldonado when he shot him. We may not know which gunshot wound came first. But what we do know is that is the epitome of intent to kill. Because that is 2 times you have to pull that trigger. 2 deliberate times. And when we consider the trajectory that Dr. Scheel and Dr. Truesdale talked about when they used that probe, both trajectories of those gunshot wounds were in the right, up, and out the left. Almost as if they came in quicksand to have such a close trajectory to each other. Regardless, though, that's 2 times. We also have evidence that these gunshot wounds are front to back. So Mr. Lychwick is standing right in front of Mr. Maldonado. And let's not forget about the fact that Mr. Maldonado was shot in the face. That is deeply personal. That is intent. That is, I am removing this human being from this earth. That is the target. And that is a surefire way to kill someone by shooting them right in the face. We also heard from Dr. Truesdale about how there were other fracture lines on Mr. Maldonado's skull, and she talked about how that comes from the energy of the bullet, and all that energy needs somewhere to go. When we talk about then,
I don't know what happens.
How all the threats are neutralized. If that's not intent, I don't know what is. We also then consider the phone searches from Mr. Lychwick's cell phone that we recovered during the search warrant on November 26th. What's interesting here, and what kind of overlaps with the trail camera videos, is that search on April 21st of 2024, 7 days after Mr. Maldonado was murdered, and about 10 days before we see him on that trail cam. He's searching for carcass removal, disposal, how to dispose of spoiled food safely. Sure, it could be innocuous, I guess, but not when you consider everything in the totality. That timing is just too specific. The nature of those searches, the carcass, he's referring to Mr. Maldonado. That's what this evidence shows. Because at that point, he has Mr. Maldonado up on top of that hill in the area in which Moxie gave her trained final response. But this is an apartment complex. This is land that's shared by everybody. And eventually, he'll probably be discovered. And so now, a week later, we have this search of how to get rid of a carcass. And remember that DNR article had 3 options. You can either take it to a landfill, you can take it back to where the harvest originally occurred, or you can bury it. Mr. Lychwick goes a little bit out of order, but it does make sense when you think about the timeline that we've presented to you. So first, we have him on those trail cameras then, 10 days later, with all of his gear. He's got his shovel, he's got his boots, he's got the plastic sheeting, he's got that black packaging with him that looks very, very similar to all of these black garbage bags. And he is up there for 30 minutes where we don't see him anymore, from 12:41 a.m. to 1:10 a.m. And when we see the direction that he's walking, It's exactly the direction up that hill. Because then when you go off camera, you continue going up the hill, or you can divert to that footpath where we eventually found Mr. Maldonado. And there was a lot of talk about something on Mr. Lychwick's hip in that video. Detective Stern said, "I can't tell for sure what that is." And Mr. Lychwick posited that it is a flashlight. Let's go with that. Let's say it is a flashlight. It makes sense in a way because as you're up there on the top of that clearing, knowing, okay, the DNR suggests that I need to bury a carcass, so I'm going to try digging and I'm going to bring my shovel out there. There's no lights up there. So of course you need a flashlight to see where you're digging. But then he realizes this isn't going to work. And as Detective Stern talked about, the dirt up there, you can get down a little bit, but then eventually you're hitting clay, you're hitting something harder. And that shovel that we have is not something that's going to be able to break through that. He can't bury Carlos deep enough to avoid detection. So then what does he do? Landfill. That's what we're going to do with this. So he starts dragging him down because it's a lot easier to go down that hill than it is to go up that hill. So between that and Moxie hitting up there, that's where this all started. So then as he decides, I need to get rid of Mr. Maldonado, I need to get him off of this property, he has him in these opaque black garbage bags, which we saw from the Google returns. He's got the tarp as well, which helps him drag or slide Mr. Maldonado down the hill to this footpath. The ropes, when you look at those ropes that were tied to the chair in Mr. Lychwick's apartment, and you put them side by side with those ropes recovered from Mr. Maldonado at autopsy, look at those patterns. Look and make that comparison because those are the same kinds of ropes. Because he used what he had. And so even those knots, if you look at how those knots are on each of those 4 ropes, they look pretty close to those photos of the ropes from his apartment. And when we talk about intent to conceal, he's even threading those ropes through the grommets on the tarp. We have tape on Mr. Maldonado's hands. We have that black duct tape that is used to enclose Mr. Maldonado, to tie together or tape together those black plastic garbage bags. And then once he is in this footpath, and we saw a picture of Carlos, he's not a small guy. And so if it's too difficult to get him into a car to bring him to a landfill, I can't drag him back up the hill now, so he's going to have to stay here. And so then we start piling on all of those branches, all that debris, and he goes undetected. Family knows that Carlos isn't here, that he's missing, but nobody sees him anymore. After Home Depot on April 14th, we see from his phone records he comes back to 1512 East North, and then nothing. There's no movement. Nobody sees him again. That combined with what he's wearing on that Home Depot video, and that's what he's wearing when we find his remains, this all goes to establishing April 14th. And even going back to those trail cams, yes, we have that half-hour break, but we never see Mr. Lychwick come back with any of his tools or his gear until 4:39 a.m. that morning. He goes back and forth. We see him go to the garage. We see him walking back up in that direction. So that's 4 hours where he's out there and he's not exercising. That just doesn't make any sense compared to what we saw him bringing out there. So then we talked a lot about the search of Mr. Lychwick's vehicle. And before we get to that point, though, he goes to U-Haul. And that is out of the ordinary for what the detectives have been seeing in terms of his pattern of travel over the last few days. So as he starts traveling north, we follow him to a storage facility that he has no history of searching for until within 48 hours of us finding Mr. Maldonado. He had rented it, according to that receipt, on November 1st, gets that free month promotion, and now he's got to empty everything out because that month is, maybe he's moving it. Maybe he's going to another storage unit. I don't know. But what we know is he emptied it. And then we follow him. And we saw him on the surveillance emptying it. So we follow him back to Waukesha. Officers stop the car. They seize the car. There's nobody else in the car with him. And what do we find after we get a warrant to search his car? The murder weapon. Inside that trunk, we find the shovel. In the back passenger seat, we have boots. We have numerous boxes of 9mm ammunition. So for Mr. Lychwick to say, I've never seen that gun before, I don't know what it is, I don't know how it got there. You certainly have a lot of ammunition for a 9mm. So then we also find all these garbage bags. We start putting all of these pieces together here. What's important to know, and really I'll sum up Ms. Crawford's testimony. She told us all about firearms identification and how we have those striations and those grooves and the manufacturing characteristics versus the individual characteristics. But here's the bottom line. These two projectiles recovered from Mr. Maldonado's body were fired from this gun, period, end of story. So now you have an individual who is targeting the victim. He has his name written in notes. He is up in a trail area at the top of the hill. He is hiding evidence related to a homicide. And you heard on that recording, they were tearing up everyone's apartments and I had to get my war bags out of there. Your war bags with the murder weapon? Thank you very much. So now we have this, and Ms. Crawford says, yep, this is the murder weapon. Now we go and arrest Mr. Lychwick. We get his buccal swab, which you've heard a lot about. And this is another reason why this whole theory of, I've never seen this gun before, I don't know anything about it. His DNA is all over that gun. When we heard from Ms. Taylor, we talked about the swabs from the grip of the Luger. And it's, in the state's view, important because this is a single source profile. There is no mixture. There is nobody else's DNA from the swab of the grip of this Luger. And it's Mr. Lychwick. And you heard Ms. Taylor talk about how in order to find another profile, or it would take us testing a quadrillion people to see a similar profile. There are not a quadrillion number of people in the world. So there's no question that Mr. Lychwick's DNA is on the grip of this Luger. Then we also look at the towels and the rubber bands. The exterior towel is a mixture, but we have very strong support for inclusion, which is the highest reporting level that our state crime lab has. We also see that quadrillion number again. And then we get to the interior towel, which is back to a single source profile. And it's Mr. Lychwick's. So, ladies and gentlemen, sometimes, and you heard Mr. Lychwick talking about it, objecting to it, sometimes little things, they might seem, well, everyone has bleach. Everyone shops for hand soap. Everyone shops for garbage bags. True. I don't dispute that at all. But you can't take everything and just look at it individually in a vacuum. Your role here is to search for the truth, not to search for doubt. And the truth is that on April 14th of 2024, Mr. Lychwick murdered Mr. Maldonado. And all of the evidence is right here in front of you. And so I'm asking you, when you go back there to deliberate, that you hold Mr. Lychwick accountable and you find him guilty on both counts. Thank you.
Thank you, Attorney Thompson. Mr. Lychwick, you may give your closing argument. You may stand at council table if you would like, and you can also use the lapel microphone if you want.
I think this microphone will suffice, Your Honor.
Go ahead, then.
Suffice.
Ladies and gentlemen of the jury, thank you for coming and giving your precious time and effort to this case. I ask you now to do what you must do to acquit me of these horrible charges. I am totally innocent of this crime. I did not know this man well enough to hurt him. He did not know me well enough to have attempted to hurt me in any way. We were neighbors, but we did not know each other. The defense argues that I went on top of the hill. They take broad liberties with the truth and with their idea of facts in this case. But the fact is they have no proof that I was ever even on top of that hill. I have established that I have a right to be out in my own yard and do whatever I do. They have no proof that I even spent all the time they're saying I did on the night in question when they're insinuating that I had something to do with the handling of poor Mr. Maldonado. They don't know that I went home and that I was on a hike looking around for possums that lived in my yard and feeding my rabbits because I couldn't sleep that night, that I normally would put my tools down and go for a run up and down the hill or a quick trip to buy groceries at all hours of the day. During the daylight hours, I use a jogging suit. At night, if I'm out in my jungle...
I'm going to object at this point. This is all testimony and none of these facts are in evidence.
That's sustained. Mr. Lychwick, I caution you, you can argue inferences and argue what the state doesn't show in their evidence, but you can't testify about matters that have not been testified about. So just be careful that you're not trying to introduce new evidence or testify in any way. You can continue.
Ladies and gentlemen of the jury, as you were instructed to do so, I implore you, if you have any doubts in this matter, to find me not guilty. There are plenty of doubts in this case and what the prosecution has established as their case against me. The accusers, the Waukesha Police Department, headed by the investigative team of Detectives Benjamin Stern here. I implore you to weigh in consideration of my innocence in this matter and to take into consideration the manner in which they executed their search warrant.
He still has something stuffed in his ears.
The search warrant being established originally because one of their detectives asked me, I think this has been established as evidence already, asked me about the presence of plastic bags in front of my car, in which I truthfully answered the detective, telling the detective that I moved my shovel and everything into my car for winter.
None of this is in evidence.
It has to be.
It's sustained. It's not in the trial record. The jury has not heard any evidence of this, and the legality of the search warrants and the manner of their execution is not an issue for the jury to determine. You can continue, Mr. Lychwick.
If I may, ladies and gentlemen of the jury, I have been unable to present a hearty defense in this matter because I have been imprisoned in the Waukesha County Jail for 18 months now and isolated from my funds and my family and my friends and my ability to hire an attorney.
Okay, Mr. Lychwick, stop, please. Again, these are not matters for the jury to consider. They are to consider only the facts and evidence that was presented in the case, not what could have been, not what wasn't, only the facts and evidence that have been presented. Your status during the pendency of this case is not relevant and should not be matters for the jury to know. But you introduced it, but it should not be for them to know. So focus on the issues here and the evidence that has been received in the trial this week, and you can continue your arguments.
Your Honor, you noted these protests throughout the trial.
I have. Now continue.
Ladies and gentlemen of the jury, I implore you again, if you have any doubts as to my guilt, please find me innocent. I have a life out there. I am a good man. I am a God-fearing Christian. I just want to go home. I want to resume my life. And when I go home, the Waukesha Police Department and anyone assisting them will be able to continue searching for the actual killer or killers of the poor victim in this matter. As long as I am in custody, they have stopped looking for who actually killed this man. Imagine that whoever did this is still on the street. I implore you to please send me home. Find me not guilty in this matter, because I am not guilty in this matter. And owing to the corruptibility of people and human nature, I am telling you there is a corrupt element within our local Waukesha Police Department. And if you find me innocent, perhaps there will be some house cleaning and they can take care of it. Somebody will investigate this matter and we will all be a little safer. I thank you for your time in coming here again. And again, my final statement to you is, if you have any doubts in this matter, if you have any doubts about my guilt, please find me not guilty.
Thank you,
I
Mr.
rest my
Lychwick.
case.
I rest my case. Well,
any rebuttal closing, Attorney Thompson?
Very briefly.
He brought his entire piling system.
What I'd like to posit to the jury is there's probably someone else who really wants to go home or wanted to go back to his apartment that night.
I object, Your Honor. She's already had her chance to make her statement in this matter.
The objection is overruled because the state bears the burden of proof in this case. It is allowed by law to give a closing argument and provide a rebuttal closing. So the state gets the last word. Attorney Thompson, you may continue.
Thank you.
You didn't know that.
Mr. Maldonado had plans with his daughter, and she never anticipated that he wasn't coming back to his apartment that night. And so who's responsible for that? Mr. Lychwick. So let's all remember why we are here. Because Mr. Lychwick murdered Mr. Maldonado. And that's what this evidence shows. And the law that the judge read you is not, if you have any doubt, you're not searching for doubt. You search for the truth. And the standard is not beyond all doubt. It is
Objection,
beyond.
Your Honor.
She's
trying to instruct the jury to find me guilty.
I disagree, Mr. Lychwick. The state is reciting elements of the reasonable doubt instruction. That's permissible. And ultimately, ladies and gentlemen, you are bound to follow the law and the instructions I give you, not the law and the instructions the attorneys may interpret or recite. Ultimately, what's in the jury instructions is what you follow. Attorney Thompson, you may continue.
Thank you. As I said, it's not any doubt. It's not even beyond all doubt. It is beyond a reasonable doubt. When you look at all of these pieces together, just like Dr. Truesdale said, the bones tell a story. They tell a story about someone's life. And all of these pieces of evidence here tell us the story of how Mr. Lychwick murdered Mr. Maldonado and then hid his body so that nobody would find him and hopefully he would get away with what he did. So I'm asking you to find him guilty on both counts. Thank you.
Thank you. Now, members of the jury, the duties of the parties in the court have been performed. This case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 4 forms of verdict will be submitted to you concerning the charges against the defendant, Kevin Lychwick. As to count 1, one verdict reading, we, the jury, find the defendant, Kevin W. Lychwick, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we, the jury, find the defendant, Kevin W. Lychwick, guilty of first-degree intentional homicide as charged in count 1 of the information. As to count 2, 2 verdicts. One reading, we, the jury, find the defendant, Kevin W. Lychwick, not guilty of hiding a corpse as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Kevin W. Lychwick, guilty of hiding a corpse as charged in count 2 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case, and therefore before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any question in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. We will first swear the officer and then strike the alternates.
He's not talking about physically striking.
You swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them, or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon. So help you God.
I do. Ladies and gentlemen, there are 14 of you, and we can only allow 12 to go back and deliberate on this case, which means we must strike 2 jurors at this time from the jury pool. Those alternates are picked by random. It's probably disappointing if you get selected as an alternate because you've sat through all of this trial and you can't participate. But understand that we pick alternates the way we do just to guarantee that if any emergency comes up or we lose a juror for a family emergency or a medical situation, that we can continue the trial. So we build in a little bit of a buffer to allow for that to happen, especially on multi-day trials. So I have the list here with the alternates. If I read your name as an alternate, I ask that you stand, please.
I'm going to mute
the alternate names. Jurors are and name.
There we go. Muted them.
What we're going to do is our jury bailiff will escort you back to the jury room to get any belongings that you may have back
like
there. I'm going to ask the other jurors to remain where they are for now. We'll have those jurors go collect their materials, then they can be released. And once that's done, we'll have the other jurors retire to the jury room.
can give it to her.
Everyone's got a dozen eggs back there. You need to go collect. What was the result of the guilty, not guilty poll? 86% of you said guilty. We have a poll up going right now. How long will the jury deliberate? Juror number 1, can we have Exhibit 1B? Oh, no. No. Can't have any exhibits. Did definitely waste opportunity by his antics earlier in the trial. Don't know the makeup of this jury. We don't have a court watcher there. At least that I'm aware of. Wait. We do. We do know the makeup, don't we? I thought we did. I'm looking at the Alaska trial and answering for that one. Let's get the counter ready.
I'm now providing a copy of the verdict forms and 12 copies of the jury instructions to the jury bailiff, and the jury may now retire and begin their deliberations.
All rise, the jury.
All right, the jury heads out. The jury bailiff takes, and when the door closes, we start the timer. Everyone's filing out.
Thank you. You may be seated. We are now outside the presence of the jury. If the jury requests
1B.
any of the photographs that were used and published, my inclination would be to provide those to the jury without calling the parties back to go through each one that they've selected. Mr. Lychwick, I recognize that you've objected to a number of the exhibits being introduced. The exhibits that have been introduced and already used with the jury, I would send those back if they request. Do you have any issue with that process?
Yeah, where's
I
mine?
certainly do, Your Honor. Especially if I entered a prior objection to them.
And your objection would still be noted to those exhibits, but my point is that they've already been shown to the jury. So if the jury asks a question, I would have to bring you back into the courtroom. I'd have to bring the state's attorneys back. We would confer about the question, provide an answer to the jury. Sometimes that takes a little bit of time, and that's what we will do for ordinary questions. Other times the jury says, hey, could I see exhibits 120 through 130?
Or 1B.
If those are all photographs that have already been displayed to the jury on the screen, I'm not going to bring the parties back and talk about whether or not those should go back to the jury because they've already been displayed in court. The jury has already seen those. They're just asking to see them again. For photographs, I'm just going to send those back to the jury. For other things where parts of them may have been published, for example, some of the reports were published but not in their entirety, I would not be sending those back automatically. We could discuss that. But I'm just talking about just regular pictures, one-page picture files. If the jury asks for those, I'm going to send them back without bringing the parties in to talk about that if they've already been published. Understand?
Yes. I think so, Your Honor.
Okay, that's fine. And I was going to go to the state. Attorney Thompson, that's fine with you?
Yes, I'm sorry.
That's fine. If there's anything else where I see they've requested another exhibit that may have been published in part or something other than just a simple photo, I'll call the parties back. Then with the issue of the videos, if they request to see any of the videos, we do have the capability of streaming the videos directly back into the jury room. We can either do it one of two ways. We can stream it back in the jury room, or we can bring them back into court and play it again on these monitors. I'm going to decide to stream the videos into the jury room. The way we do that is we have one of our bailiffs go back to verify that the streaming and the live feed is live. We will play the videos twice, and then that'll be the extent of how they're played back. Because we can't just send a thumb drive and the videos back to the jury and let them poke around with the videos. We have to control the playback. So that would be the process for the videos. If there's any other questions or any other exhibits that they want to see that don't meet those, well, sorry, let me just be clear. If we live stream the videos, I'm calling the parties back and we'll reconvene. We'll do it on the record. We just won't have the jury brought in. But otherwise, simple request to see the photographs. I'm not going to bring the parties back to do that. Anything else from the state then before we wait for deliberations?
No, thank you.
Anything else from you, Mr. Lychwick?
Well, thank you, Your Honor.
Okay. Then the state, please provide some contact information, and we will stand in recess until we have a verdict.
All right. We now go into standby mode. Let me see if I can get this timer working. For those that are having buffering issues, here's what I recommend. If you're on a computer watching, have the YouTube page open, hit the space bar, wait about 2 seconds, and then hit the space bar again. It will put you 2 seconds behind live. That's not very much. But it might be enough to fix any buffering issues. YouTube's just having trouble serving up all the video you guys want to watch. I can tell you that it's not on my end because I can see, I can monitor my full internet pipe, as they call it, and bandwidth. I'm on fiber here. I've got a 2 gigabit symmetrical connection, and I'm using about 2 megabits, which is a fraction of that for this stream, and I've got lots of available bandwidth. Also, no, it's not a problem on my end because some people aren't having any problems at all, and so if it was a problem on my end, it would have to happen to everybody. But YouTube is having trouble keeping up. So that's a bummer. All right, let's see. World Cup has started. Woohoo! Congratulations. Yay, go team. Yay, sport. Let's have a poll for YouTube. Happy or not? No. I'm watching on TV with Wi-Fi and no problems today. Goldilocks, that's awesome. I've had to do that for months now. I can't be live. All right, is fiber flexing? Hey, nothing but the best here. We insist on having the best. Stream has been perfect all morning. Eman, that's wonderful. Cell phone, awful. I'm sorry, Waffles and True Crime. Lots of problems for months, says Gabby for Justice. We have a poll going right now on how long the jury will deliberate. And I think of all the times, this will be a short one. That's where I'm coming in. I've already made it known. The options on the poll, if you haven't voted, I'm going to read them very quickly. They are this. How long will the jury deliberate? Less than an hour, 1 to 2 hours, 2 to 4 hours, or I said sleep on it, but I spelled sleep in it first. That's different. Sleep on it is what I meant. It's not a sleeping bag. It's a verdict form. So we're going to end the poll because we've got 559 votes. I like a nice round number. Let's see. 562. Last few minutes, let a few more in. 568, 569. Stop at 570 maybe. Nope, 573, 574, 575. I'll wait till 600. How about that? Because it's going up fast right now. Can't wait to go up to Alaska in this next trial. There's a lot of flannel in that trial. A ton of flannel. 582, 18 more, 11 more, 589. Get your votes in now, folks. Speak now or forever hold your peace. 590. 593. Let's try to stop it right on 600. Here we go. 595. 96, 97. 3 more. 598. Nothing wrong with flannel. No, I love it. 599 and 600 and the poll. With one more vote snuck in with 601 votes. The results are as follows. How long will the jury deliberate? Let me post them on screen. Copy and paste. 1 to 2 hours was the winner with 54% of the vote. Less than an hour, 32% of the vote. So a strong showing for a short deliberation. 2 to 4 hours, 13%. Sleep in at first, 1%. That's all but 6 of you. I did the math in my head. All but 6 of you think that technically it could have been 4. All but 4 to 6 of you think that that this will be done here this afternoon. So 601. I missed it. I clicked right when it went to 600. Sorry if you guys didn't get to vote. Hopefully you're... That's easy math, because you just have to divide by 100, right? It's a percentage. Longer to choose a foreman than verdict. They go back to the verdict room. They're like, all right, who writes the fastest? Which one of you writes the fastest? Because we're ready. 4 hours, verdict today, says Charm. The Alaska trial, the husband accused of killing an Army wife. We'll be jumping up to that in a little bit. I'll tell you, it looks like this right now.
Right into the living area. Bedrooms are to the left.
And it's pretty good audio. There are parts. Some of the body cam interview stuff is rough without video, and the audio's a little rough, but it's not very long. Prosecutor gets a B+ on closing, but only because she could have tightened it up better and used Occam's razor in her rebuttal. I will tell you one thing. On her closing, I realized that I had heard something wrong during trial. I was sure I had heard during the DNA testimony that the victim's DNA was found on the gun. It was found in the trunk of the defendant. And no, it was the defendant's DNA that was found on the gun. Now, we do know also from the, I guess Runkle would call it the fortune teller, the firearms and tool marks lady, that the bullets that were fired from the gun were matched to that gun. So there's a connection connecting the 3. But I thought for sure it was the victim. But in her closing, she just said it was the defendant's DNA. And that's important because the defendant says, not my gun, never seen it before, don't know where it came from. He actually tried to insinuate that the officer had found a gun in his car, but it was a .38, not a 9mm. And he said, you stole my .38 and planted the 9mm and planted my DNA evidence on it. That was his attempt at that. Yeah, Law and Crime does have a camera up there. According to court's rules, we're not allowed to live stream anything other than the court's feed. So I've seen some other Law and Crime and some news channels and stuff. They have cameras, a whole bunch of cameras there in the back of the courtroom. And so there will be some other angles of the same stuff that we've watched that'll come out. But not much extra that we didn't see already. I wanted to hear that theory. I wanted to hear more about the twin. We only heard about the twin theory because the state asked a question about whether the police were able to determine if the defendant had an identical twin or not. And so they're the one who opened that door. So clearly at some point that probably got raised. Yeah. All right, let's get if we go back here, where's our timer? Timer's at 11 minutes. 12 minutes. Let me fix it a little bit. There we go. I'm his identical twin. The verdict is in. I don't know. That's fast. I'm not seeing that yet. Tomorrow we have a couple things. We have a first thing in the morning. We have a Tyler Robinson. Well, it's not first thing. I think it's about 11 o'clock. We have a Tyler Robinson hearing. I'll have to check on the time schedule for that. That is... Oh. Fox 13 is no longer able to be pooled for the initial appearance for Jimmy Haas tomorrow because they're covering the Tyler Robinson hearing. If you'd like to apply for a pool, please submit a request. I'm good. I could do it. Tyler Robinson tomorrow. Jimmy Haas, that's an interesting case out of Utah. Taylorsville, Utah, I think. That's a police officer charged with murder. I believe there was a pursuit. There was some sort of pursuit, an altercation that ended with a pursuit and a crash. And then the officer jumped up into the truck or something and shot the guy through the back window. And he stumbled out and collapsed, took him to the hospital, and he died. That officer is, and that's in Utah, that officer is being tried for murder. This is very interesting because I'm not getting into politics here, okay, but this is just a pure fact. Sim Gill, attorney general, the attorney, whatever the guy's name is, Sim Gill, the guy who decides whether or not they prosecute a case that involves a police officer, has had a lot of cases presented to him looking to prosecute, and he has failed. He has neglected to prosecute or chosen not to prosecute all of them, since 2014. None of them have been prosecuted. All of them have been deemed justified. This is the first one that he's actually gone forward and pressed, forwarded some charges on. So interesting. Yeah, you've got American Fork, Legos. You've got all sorts of stuff down there. American Fork's going to be in a world of hurt. I imagine they might have some legal battles ahead of them, right? Because there's some problems. Wonder what the difference is. We'd have to get into the facts of that case to see what it is. It is important to note that the defendant did not have a firearm on him or a weapon of any kind in the vehicle or on his body. And there was no, from the body cam of everything that happened, there was no statement that I'm aware of that there was ever an observation of a weapon or a threat or perceived weapon. It almost comes across to me as an officer who's really mad that someone was running away from them and maybe took things into their own hands. So, yeah. The Lego thing is wild. Oh, fun fact I've learned about Legos. Oh, the Lego company, or I'm doing it wrong already. The plural of those little bricks, those stick-together brick blocks that hurt so bad to step on, is Lego bricks. It's not Legos or even Lego. Lego is the brand, but the Lego blocks or Lego bricks would be the plural form of that. Do you know that? EDB did a Lego video. Lego my ego. Can you tell us why the conviction was overturned for Adam Montgomery? Yes, Miss Mary, I sure can. The big reason is the way the charges were grouped together with the assault and murder together. The state said, because you did that, we're overturning it. Because it was unfair to Adam Montgomery. It has nothing to do with was there sufficient evidence or this couldn't be proven. It has nothing to do with that. And Adam Montgomery, he's not celebrating and about to head down to the local store and tell all on the street corner. He's not getting out because he pled guilty to a whole bunch of stuff, except for those last couple charges. He pled guilty to those, and he's been sentenced on those. He'll remain in custody on those charges. But because the state grouped the murder and the assault charges together during the trial, that was improper. The state says that was, foundational error, and he has to go through the same process again. So terrible news for the family that has to relive this, and the community that has to relive this. But I think they will re-prosecute and get it right. How was the EDB video about the TRO? I still need to watch. The temporary restraining order. I don't know. She like, hey, this is weird. Okay, I just saw the tease on that, but bricks and minifigs and Lego and some guy in American Fork and the American Fork Police Department. It's all a funny one. I currently have a Lego addiction, and boy, is it expensive. It's primo stuff. I've bought a couple sets so we can do some builds, and they're nice. They're fun. I mean, my family, you realize, 6 kids. We've gone through a lot of Legos, and we buy ours in bulk, usually used, which sucks because you don't get to build the really cool sets because there's always pieces missing. But we've gone, and I think at one time we bought 18 pounds of Legos in one go. You know those triple drawer, those plastic drawer sort of bins that you can buy at like Walmart or something. We bought 2 of those completely full with 6 drawers. And one of them was like just figurines. It was wild. Can't you 3D print Legos? You can 3D print objects that might interface with Legos, but Legos are injection molded. And the 3D printer just doesn't compare. All right. Australian are making fun of American Fork Police for the Lego. They're making a Full House Lego set. I can't wait. Full House. Man, that's throwback. What's the point of retrying people that are already spending life in prison for other charges? Gray Lady. Because believe it or not, just like this murder charge could have got reversed, it's possible for the other charges also to be reversed, or for someone to be, to have that outcome overturned. It's possible for that to happen as well. Now, it's very rare, and it would take a pretty unique set of circumstances for that to happen. But if it did for some reason, you'd now have him out on the street, and you're like, whoa, we thought he was guilty of murder, and we didn't recharge him because we were like, oh, it's okay, he'll never get out. But then he did. They don't want that to happen. And there's also a feeling that the victim doesn't get justice if there's not a prosecution in their case, if there's not a conviction in their case. Didn't even know American Fork was a place until all this drama. It's actually a beautiful place. American Fork Canyon. I think that's where the Timpanogos Cave is, which is a cave way up the mountain. You have to hike for like days to get there. It just seems like that. But beautiful, huge cave with stalactites and stalagmites, and it's a like national park or something. Maybe it's a state park. I don't know. But it's a beautiful canyon. It's the only place I've ever found gold of any, sizable amount. A lot of fun to go exploring up there, riding motorcycles and getting chased by bears. Listen to Runkle read The Suit. That was interesting. I worked for an online Lego reselling store for 10 years before we went under. Sorry, went under. Victims also deserve justice. Yes. Star Wars Lego girl here. My expensive hobby is worth it. Be sure to scan the code on the booklets for Lego points, also known as Lego dollars. I think I have some Lego dollars from all the different sets that I've bought. Because I bought the mosaic. Remember the mosaic we did? I bought the mosaic set and then the garbage truck. And I forget, we bought a couple of them. As business expenses, clearly, because they were research or for use during the live stream. Goodman Law Firm. I'm out hiking right now. Send us a proof pic. We need a pic, or it didn't happen. Bought my son so many Lego sets. there's some cool ones that keep showing up at like Sam's Club, but the price is just through the roof. Mosaic was so much fun to build, but it hurts. Of all the Lego sets I've ever built, that one hurts because the pieces are so small. You're just like bruising your hand constantly. Britta, have I seen the milestones from this morning? If they're still here, let me look. Did I miss some? I can't see milestones from this morning. I see Bite Me for 41 months and Purple Coconut for 6 months. And Laura for 25 months. That's going to be epic. This is going to be epic. It was, Laura. It really was. Texas Lawcat with a super chat. Debar, welcome to the gallery. Welcome. Christina gifted 5 memberships. Josh gifted 5 memberships. Thank you, Josh. Christina Gibson, member for 17 months. Time flies. Love it here. Allie Foley, be sure to scan the QR codes. That's good to know. I don't think I keep any of the book. The booklets are like for cheaters, right? That's like when you get the New York Times and you wait to do the puzzle till the next day and you use the answers to fill it out. You should just be able to look at the picture on the cover of the box and dump all the bags into one big pile and just assemble it. That's when you're a true Lego master builder. I'm sorry, if there were other milestones, I missed them, and I apologize. Britta Aller, how many months? Where are you at? I sent mine this morning. We put a bunch on screen, Britta, if you sent it during court, while court was talking, we put everything that popped in on screen, but I didn't announce any of them. But you most definitely are an OG, if we can call that one out. It's only cheating if you get caught. I use the Lego Builder app instead of the booklet. That is cheating, though, Allie. That's cheating, right? That's basically having the only thing worse would be having someone else build it for you and then claiming it as your own. But no, you're still doing the work. We'll be bookmarking my Lego page. I didn't discover Legos until I had a son. I'm new here. Jenny Lynn, Legos are great. Goodman Law Firm comes in 40 months. OG. On the jury as well. Awkward, but my relationship with this channel outlasted my first marriage. This is great. Nicole, that's wonderful. Welcome. I hope you're enjoying your hike today. Hope it's beautiful. And no smoke, right? There's fires all over the place right now. Gabby for Justice, member for 23 months. OG. I think I'm 1 month to... No, 20 months is the OG threshold. So you're 3 months deep. Gabby for Justice, thank you very much. Best channel on YouTube. Very kind words. I appreciate the compliments. Not really well-deserved, but I appreciate it anyway. Misconduct, member for 38 months. Another OG. Recovery Addict. But really, have you used any of the light kits? They're pretty dope. The Lego light kits? I've seen some of them. I've never bought a set that has that. Maybe we'll have to do that. Britta Aller is an OG. For sure, Britta. Let's see. Thanks, no smoke. It's gorgeous out, breezy, and about 70 degrees. I will trade you. I'll trade you. It's like stifling hot and a little bit muggy here. Oh, I don't think Lego makes them, but they work. Okay, I have seen those. Which one was I looking at? I had a set that I was thinking about using light kits. It was a eBay light kit for it. I have a light kit from Milky Way, but I don't want to take it apart and install it. Well, that's a beautiful one, though. You've got all the stars and everything. That'd be cool. Susie64, member for 27 months, also an OG. I want my member... OG! There we go. I want my member emojis back. Love it here lurking. Where did they go, Susie? We have some people who say they cannot find the emojis and other people who are finding them. I'm not sure if YouTube moved them. I still show them as available. I had to dig for them, but they're still there. Like, I mean, there's the shovel. That's one we made. Red, what's going on? I cannot dismiss your pinned comment. I will dismiss it for you because we're done with that one. How about that? Nope, I can't. I can pin it, and then I can unpin it. This is weird, Red. Your account's crazy. Have you decided to get the night vision equipment? A polite one. A great question. Yes-ish. But I was looking at ATN, which is actually a rifle scope with night vision, and dug deep into the reviews. I could get it to work. It would work that way, but it's either a 3 to 15 power scope, so like 3 times magnification up to 15, or 5 to 25. And I thought, well, 5 to 25 would be best because then you can really zoom in. But I saw some of the reviews of the scope, and they're like, it only works for like 200 feet, and you need an illuminator to make it work at all. And it's just, the quality was not what I think we would need. So I'm looking instead at a, what is it, a Sony AG or AX65 Pro or something, which is, it's more of a handheld video camera with the infrared option, which is a lot higher quality, but it will just take, I'll just take more time to save up and buy it. But it also has a direct connection SDI out that can go straight into my switcher, so I don't have to be plugging in like USB-C to HDMI, HDMI to SDI, SDI to, yeah. I don't have to do all the conversions. Katrina Bunny, your feet are very painful but very effective Lego finders. Peter Tupperware, thanks for the gifted membership. Shelly Small, 9 months. Congratulations. And then Mommy Sharshar gifting us some sunshine. Thank you for that. I have an iPhone, so I guess that's the problem. I think we can safely say that that some users are experiencing problems because of the server they're connected to on YouTube. Like, YouTube doesn't just have one computer you connect to. There's a whole, buildings full of it. And I just got a text message from the ATN, the rifle scope company, trying to get me to buy from them. Maybe if they sent me a free one, I'd try it. But depending on which server you got, there are subtle differences. Some features are available on some servers and not on others, and it's just weird. Sounds like the same kind the ghost hunters use. Similar. My life is trying not to slide on magna tiles. Josh says, I'm purchasing an iPad soon. iPad Pro or iPad Air. I will tell you this. The people that I know who have purchased the giant iPad love it. Like, they use it so much more, especially if they use the pencil and things like that. They use it so much more than the people I know, like myself, who have the smaller iPad, like the iPad Air. They're great for watching things on, but if you're going to be drawing, if you're going to be editing, doing any sort of work on it, that big iPad Pro, that's a beauty. It's a beauty. You just have to sell a kidney so you can afford it. Princess Sugar Plum, member for 15 months. How far will you travel for breaking news on this channel? Day's flight. I'd like to I'd probably stay in the 48 contiguous states, the lower 48. Yes, either 12.9 or 13 inch. They're great. Get a free one to buy one. What I mean by that, Blue Star, is some companies will send out a trial, a sample, tester product, which I'd have to send back after I finish testing it. And if I liked it, I'd buy one. So I'm saying, ATN, if you're out there listening, I'd love to test one of your night vision scopes. It has to be the ATX X-Sight 5, because that's the last one that had the ability to output video. It can't be the 6 model. And I'd like to test it out, and if I like it, I'll buy one. you ever tried to tether two laptops together so they work as a single computer? I've used Mac's shared computing for rendering video using Final Cut. But as far as actually just making two computers work as one, I've just found it's easier to just get one computer that's really powerful. I have a brand new MacBook that's less than a year old, and I never get to use it. Why? They're wonderful machines. I love them. I don't have one of the new ones, obviously. I'm still running the, what model do I have? I have the 2016 version, so mine's 10 years old, but it still works great. Love it. Oh, my hubby took it over for work. See? Now you need two. You need two. You have to get one for him and one for you. Can't wait for Alaska. Maybe go there instead of buying caviar. I don't know, a flight up to Anchorage, that's quite a ways. USB monitor for the win? No, I can't. Let's see. Ode Pro KL62 Plus. Now you got me Googling here, Nicole. Ode Pro KL62 Plus. That's the flashlight. That's the illuminator. That works great. Missy Pants, 40 months. Happy to be here. OG. Thank you very much for your support. And Portrait of Jenny. Thank you very much for the LOLs. Okay. Shelly Small says, my daughter took a cruise to Alaska and said it was beautiful. My friend up there takes pictures occasionally. We see some updates, and I'm super jealous. Super jealous. All right. What's that on my screen? What's on your screen? You see the stopwatch, 35 minutes, the counter. I think you just stick with the pickle pizza and say no to caviar. Some people have suggested I put the caviar on the pizza. I think I only am able to afford enough caviar to put caviar on one slice of pizza. I don't think I can make a caviar pizza. Plus, they say don't cook it. Ooh, 940 nanometers for complete stealth. The 850, I can see a little bit of the 850, I think. Looks sort of purplish. Caviar only pizza. Oh. It's a crazy cartoon. It wasn't me. Oh, you might have these little things popping up. Where were they? Hang on one second. Some of the little stickers, I can't make them pop up again. I don't know where they went. But they just dance on the screen. Missed his closing. Should I go back and watch? He implores you to find him not guilty if you have any bit of doubt in your mind. That's his closing. And objection sustained, objection sustained, objection sustained. I'm looking for a good camera with IR, Nicole. And I'm pretty sure I'm never going to be using it in complete darkness. I'll always have some light. This case is a travesty. He didn't say travesty once in his closing. Bunch of laughing penguins popped up. Yes, those are the YouTube's new version of the super stickers. That's the jewels. If you haven't spent your jewels, YouTube does give you free jewels. I think they give you like 1,000 of them. Feel free to spend them here. We would appreciate that. It doesn't. If they've given them to you, it doesn't cost you anything. If you have already used them and you buy more, then of course that's on you. Did he say railroaded? He said something similar to that. Had caviar once, disgusting. Those little eggs go all over your mouth, so it's hard to spit out even. Don't forget the objection because the state said he was guilty. Yeah. Tumwater Troy, thank you very much. I can't click on it, but thanks for the coin. All right. Thank you for the rose, Blue Star. The jewels. Oh, I can click on this one. Flow state. I don't know how much it costs as far as how many jewels it costs to do these. But some show up that I can click on and some just show up in, well, this was 200 jewels, so it shows up. But the 30 jewels and the 10 jewels didn't. So somewhere there's a threshold of what shows up on the screen and what doesn't. Why am I not green? Blue Star, you are green. I see you as green on my screen with the courthouse next to your name. It's only there if you're green. Hey. Let me see this camera. Psionics Aurora Pro. What's the output on it? It looks cool, but I need one with an SDI output, 3G or 12G SDI output. Thank you for all the flowers and the jewels. That's awesome. Big Sky DMC member for 39 months. Missed 37, 38. Now it's 39 months with the best audio and the video in business. I'm an OG. You are, in fact, an OG. Thank you, Big Sky DMC. Welcome. I never got my jewels. I don't know why. I don't know why they don't work. If you put a poll up, I missed if you have. Misconduct, we did 2 polls today. We did guilty and how long will the jury deliberate. Guilty was, I think, 86% came back as guilty on this one, which was pretty strong. And as far as the deliberation, most of us are under the 2-hour mark. And since 40 minutes has already passed, we've got about an hour and 20 minutes, or else most of us are wrong. I got jewels and spent them immediately so we don't have to see them again. I think RA should take the Caviar Farm Tour. Northwest, thank you for that. The Marshall Company, the Farm Tour, I did look at that. They only offer 3 tours this year, and the soonest one is in July. I'm going to eat my caviar before then, but the tour sounds very interesting. I've always been interested in aquaculture, having had my own aquaponics system at one point. Water filtration and pumping and circulation and raising fish, that's something I love. Sentencing today, possibly. The judge said the jury should not be concerned. They should not concern themselves with the matter. And so the judge will handle it. Wisconsin, unless there's a mandatory minimum, I think they're going to do a PSI, pre-sentencing investigation. What were the time frames? I think I picked the second. That would be 1 to 2 hours. Thanks for the happy poop, true crime. I love that. Did the defendant already present his closing, or is that coming? He already did, Wagger. You missed it. It was short. It was about 40 minutes ago, a little over 42 minutes ago, if you rewind. What caviar is Thomas getting? I don't know. But he's probably getting better stuff than me because he's got the advantage of having it before. I never have. One of my sons wants to have a self-cleaning system complete with a mangrove in it. AC's Wildflower, I had an aquaponic system that used those IBC storage tanks, like those pallet-sized square tanks. I had one above ground and one sunk, like a half or three-quarter tank sunk down below. That was my sump. And so I had one pump that pumped from the sump up to the top tank. That's the only electrical input I had. And that pump filled the tank, and it would overflow through a careful filter that fish couldn't get out into a swirl filter, which is a barrel that swirls and heavy solids drop out. And then I can siphon that off every once in a while just to take the solids out, which is really disgusting. It's the smelliest, stinkiest sludge that comes out of there. So it's not for the faint of heart. But the swirl filter the exit from the swirl filter and then go into a media bed, which had a bell siphon. A bell siphon is something that allows the water to fill up, and as it gets full, it automatically creates a suction vacuum, which rapidly drains the whole system and then resets. And so it doesn't take any electricity. It's something I built just with PVC pipe pieces, and it has this float and siphon system. So it would fill up the media bed and then drain, and it'd fill up over 45 minutes and drain in 60 seconds. And then from there, it would drain into a raft system, which was a big, long, like a wading pool that had floating styrofoam rafts with little net cups with, I think it was coconut husk as a media, and I'd grow plants in there with their roots hanging down into the water. So all that cleans up the water, and then the water goes into the sump. And I had a couple fish in the sump, and I had fish in the big pool, and I'd feed the fish. And so that's how it worked. Skeeter, thank you very much. Do you have a favorite trial you've covered? And there have been moments of trials that have been really good. I mean, even the crazy Las Vegas walk through, the guy shot his wife, was it? No, he shot his wife, and then he shot the guy that he framed for his wife. Tommy. Wasn't that his name? I think Brandy called him Tommy. That one had moments. RA in hydroponics means he's moving to Colorado. No, but I would like to move to a state that would allow me to do that again. Utah was not friendly to aquaponic systems. I filled out requests. I filled out applications, petitioned different people. The Fish and Game have set up in one of their offices an aquaponic system. They're like, hey, check this out. And then they build the rules that make it almost impossible to do an aquaponic system. They're like, you guys should do this, great sustainable farming, gardening at home, everything. It's wonderful, fish culture, everything. And then they set up these rules that make it cost so much to even get started and continue. And, you'd have to, it was terrible. So, El Roth, stay hydrated. I will. I've got half a bottle right here. I'm going to finish here in just a minute. Georgia allows that. A lot of the southern states do. Tellus trial was wild. Las Vegas. Yes, that was something else. Did Tracy Grist get sentenced? Yes, earlier this week. We did not follow that, even though we followed the trial. We did not have time to cover the sentencing. But the judge basically threw the book at her, said she was the mastermind that he hopes she never sees. You are banished from the state of Georgia. Yes. Hopes she never sees the light of day or ever gets eligible for parole. So that was
Lychwick matter. The appearances are the same. Standby counsel is present again in the courtroom. I have been advised that we have a verdict from our jury. We will bring the jury in.
46 47 minutes. Kevin Lychwick has not participated in most of this trial, but he's get to the most important part here. After only 47 minutes and 13 seconds of deliberations.
It's 522, just the poll.
Listen to the hot mic here. The jury has reached a verdict in this case. He's implored them, if they have any doubt in their mind, to acquit him of these atrocious crimes he's being charged with. He said this trial has been a travesty of justice. The state says it's a lot simpler than that. We just have a neighbor who, for some reason, thought it was okay to get rid of his neighbor and dumped the body in his own yard. Now, that seems outlandish to begin with, but it worked for 5+ months. Jury's coming in now. 5+ months, this body was undiscovered. It was finally discovered. They put the pieces together. They have video evidence. They have the gun. They have a hit list. They have the DNA. And they have a pro se defendant who tried in vain to argue his case before the judge. His complaints all fit in the pre-trial category. Almost nothing he presented in this trial was allowed to go to the jury. The jury instead having to make a decision based entirely on the state's evidence.
I have been advised that the jury has a verdict. Is that correct? Is Mr. Morotek the jury foreperson?
Yes.
Okay. Could you please hand the folder to the bailiff? The court will now read the verdict. In the matter of State of Wisconsin versus Kevin Lychwick, verdict as to count 1. We, the jury, find the defendant, Kevin W. Lychwick, guilty of first-degree intentional homicide as charged in count 1 of the information, signed and dated this 11th day of June, 2026, and it bears the foreperson's printed name and signature. Verdict as to count 2. We, the jury, find the defendant, Kevin W. Lychwick, guilty of hiding a corpse as charged in count 2 of the information, signed and dated this 11th day of June, 2026, again bearing the foreperson's printed name and signature. The other 2 verdict forms are left blank. Ladies and gentlemen, I am now going to do a process called polling the jury. It's going to ask each of you individually if these are your verdicts. I'm going to start in the back corner. Ma'am, are these your verdicts? Are these your verdicts, sir?
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, it is.
Are these your verdicts?
Yes, Your Honor.
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 2 more.
Are these your verdicts?
Yes.
And are these your verdicts?
Yes, Your Honor.
That's 12.
Is the state satisfied with the polling?
Yes.
Mr. Lychwick?
I don't know what to say at this point.
Okay. The court has polled all individual jurors, and all jurors have indicated that these are their verdicts. Members of the jury, with the verdict delivered, your service in this case has concluded. Therefore, you may now freely discuss the matter with any individual of your choosing, and all of my restrictions on such discussions have been removed. However, it's important for you to understand that you are under no obligation to discuss this case or answer any questions about it unless I require you at some later date to answer questions about it. This applies to interactions with the parties, their attorneys, the members of the media, any other individuals. Should you choose to discuss the case with others, though, I urge you to approach these conversations with the seriousness that they deserve. I would also recommend that any discussions you engage in are ones that you would feel comfortable having in the company of your fellow jurors and openly in court under oath.
That's good advice.
While you have the right to speak freely about this case, it is important to remember that discussions in the jury room were conducted in an environment designed to be open and free from fear of reprisal or criticism. Your fellow jurors shared their opinions fully and candidly and may not want their opinions made public. Therefore, I urge you, when you discuss the case and discuss deliberations, you discuss those from your own viewpoint and not the viewpoints of your fellow jurors. Finally, ladies and gentlemen, I have a couple of matters to still discuss with the parties. It'll take probably about 5 minutes or so. If any of you have any questions or feedback that you would like to give me, stick around in the jury room and I will come back and do my best to answer those questions if you have any. Otherwise, on behalf of Waukesha County, I extend my deepest gratitude for your service in this case. I recognize that you have devoted considerable time to this case this week, but your contribution is a vital component of our justice system as enshrined in the United States Constitution and our state constitution. So it's my hope that you have found this experience to be rewarding. You are now discharged in this case. Thank you.
All rise for the jury.
Thank you. You may be seated. We are outside the presence of the jury. Attorney Thompson, any motions from the state?
I would ask that the court enter a judgment of conviction on each count.
Mr. Lychwick, are you moving for judgment of acquittal notwithstanding the verdict?
Yes.
Okay. The court will grant the state's motion and order judgments of conviction as to each count. Mr. Lychwick, I'll advise you that you are a convicted felon now, and as such, you may not use or possess a firearm for the remainder of your life. You also may not vote until your civil rights have been restored. We will schedule this case for sentencing. Attorney Thompson, do you have a specific length of time in mind as to how far out you want to go for sentencing?
Practically any sentence here.
I am not requesting a
sentence.
PSI in this case, so at the family's wishes, as soon as the court can accommodate, please.
Mr. Lychwick, there is a mandatory sentence of life imprisonment on count 1. The court does have the ability to determine early release, or eligibility for release, I should say. One of the options you can exercise for sentencing is a request for a pre-sentence investigation. The state's not requesting one. I don't particularly need one, I don't think. But if you would like one, we could order a pre-sentence investigation. Otherwise, I could offer a date as early as tomorrow for sentencing.
I would like a pre-sentence investigation, Your Honor.
Okay. I'll allow for the pre-sentence investigation, so we'll schedule the matter accordingly. That'll go out about 60 days, probably.
It's a little late to want to get a redo on this one, but perhaps being pro se on your own murder trial was not the right choice. Maybe used a little more elbow counsel. The defendant fired 2 of his public defenders.
Thursday, August 20 at 8:30.
8:30 a.m. Thursday, August 20. The sentence will be life without parole. The sentence will be life, but the question of whether or not there's going to early release or not is the only factor. So we probably are not going to follow the sentencing there with a known outcome.
That works for the state. Thank you.
August 20 at 8:30 then. The court will order the PSI. The defendant is remanded into custody. And Attorney Galloway, the court is relieving you of your standby counsel appointment.
Thank you.
Anything else from the state at this time?
No, thank you.
From the defense?
I plan to appeal, Your Honor.
I understand. You will have that right, and I will notify you of your opportunity to appeal after sentencing. We stand adjourned.
take his reams of paper back to his cell. It didn't work. Pro se was not the way. So elbow counsel split. He's like, I'm not sticking around for anything. I wanted to be gone when he asked me to quit, to fire me. So it's done. 2 days before RA sings me happy birthday. Cass, can't wait. New trial now. It's 4:00. There is a new trial. It's on right now. It's on the Top Mark Media channel. I'm looking at it as we speak. We're going to start it tomorrow because I have to do some configuration and sorting to get it all working right. And my boys have asked that I go play laser tag with them. I think this is a terrible idea because somebody's going to end up hurt. But we're going to go play laser tag tonight. And it's going to be great. I'm sure it's going to be great. What could possibly go wrong, right? I think I'm going to pull a hammy or something. It's going to be fun. Thank you all for joining us with us on this trial. We're going to start the Alaska trial tomorrow. The feed is live right now on Top Mark Media. We'll keep that going as long as the trial continues today. And so hospital stream tomorrow, maybe. Hey, just because I'm a larger target does not mean I'm an easier target in laser tag. But the lasers have sensors; they're all the same size, so their competitive advantage is limited. So it's going to be fun. Hopefully, no injuries. Tonight, when you go home, hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning. We're picking up the Alaska trial. It's going to be great. We've got some catch up to do, but we should be able to do that in about a day, maybe a day and a half. Should get us all the way caught up. So, no podcast tonight. We'll be back next week. Thomas is on the road. We'll have stories, and I think next week's going to be caviar for the podcast too, which I am sort of excited for. Sort of not. We'll see. That might also end up in the hospital. You guys have a good night. Thank you all. Love you all. See you tomorrow. Bye.
Remember in the beginning when we started 110 years ago?
What more do you need to see?